Everyone deserves to live free from domestic violence. It should not force you from your housing, and it should not limit the choices you have about how to keep you and your family safe. In this video, we will talk about housing legal protections for survivors of domestic violence, sexual assault, stalking, human trafficking, and elder abuse.
Abuse can look many different ways. It does not have to be physical. Abuse can be verbal, emotional, financial, and it can include threats and coercion. Unfortunately, abuse can happen to anyone. Survivors can be of any age, gender, race, religion, or sexual orientation.
We will explain some of the housing protections a survivor has one by one. Move-out order for the abuser, duty to change locks, right to break the lease, protection from eviction, VAWA protections in federally subsidized housing.
We understand that as you navigate your housing situation, you're also trying to stay safe from your abuser. These options may come with risks and should be weighed carefully with someone you trust.
Court order for the abuser to move out of the home. First of all, one key tool for a survivor to be able to stay in their home is an emergency protective order or a restraining order issued by a court that tells the abuser to move out.
This type of order is called a move-out order. It allows the survivor and their children to stay housed. But keep in mind that the move-out order will expire when the restraining order expires.
Duty to change the locks. Another protection is the landlord's duty to change the locks upon your request.
Basically, the landlord has to change the locks quickly for you if you make the request with the right paperwork.
Here's how you do it. The request must be made in writing to your landlord, and you must provide a court order issued in the last 180 days. Either an emergency protective order from the police, a criminal protective order if there's a criminal case, or a restraining order made by the court. You can also provide a police report issued in the last 180 days if the abuser does not live with you. If you do this, the landlord must change the locks within 24 hours of receiving your documentation.
Your restraining order might not tell you that your landlord has a duty to change the locks. Be sure to ask your landlord in writing to change the locks as soon as you get your order or police report.
If the landlord refuses, you may change the locks without the landlord's permission. But remember, you are required to give the landlord a copy of your new key. Right to break the lease. A third tool in your legal toolbox is your right to break the lease.
People facing domestic violence often need to leave quickly, but might feel trapped by their year-long lease they signed. It is important for you to know that you can break that lease if you present some proof of your situation.
Here is how it works. Notify your landlord in writing, attach a copy of your documentation. This can be any of the restraining orders we previously mentioned, or a police report issued in the last 180 days, or a letter about the injuries or abuse from a qualified third party such as a health practitioner, domestic violence or sexual assault counselor, or a human trafficking caseworker. Or you can also provide any other form of documentation that reasonably verifies that you are a survivor of abuse. You must also pay rent for up to 14 days following your notice to the landlord.
The documentation can be as simple as a written letter from someone like your counselor. Try not to let this step hold you back.
Protection from evictions. Under the law, you are also protected from eviction. A landlord cannot evict you or fail to renew your lease because of domestic violence, sexual assault, stalking, human trafficking, or elder abuse.
We often get calls from domestic violence survivors whose landlords are threatening to evict them because noise disturbances or police calls to their home. As a survivor, you have the right to feel safe. If that means calling the police, you have a First Amendment right to do that. However, calling the police is not always a safe choice for everyone. So, if they show up at your door, you don't have to talk to them, and you should not let them in without a warrant.
To protect yourself from eviction, there are a couple of requirements. The abuser cannot be living with you currently, and you must have one of the following: any of the restraining orders we listed before, or a police report issued in the last 180 days, or a letter about the injuries or abuse from one of the qualified third parties we previously listed.
If your landlord is threatening to evict you because of an incident document related to domestic violence, show your landlord your restraining order or the police report. If your landlord serves you with eviction paperwork, make sure you file your response in time, you raise that you are a survivor of domestic violence, and attach your documentation. You should not be forced to leave because of domestic violence.
VAWA protections in federally subsidized housing. In federally subsidized housing, there are additional protections under the Violence Against Women Act, or VAWA. VAWA applies to survivors of domestic violence, sexual assault, stalking, or dating violence.
VAWA prevents public housing authorities and most landlords who receive federal money from taking action against you because of domestic violence. It can protect you from a denial of a housing application, eviction from subsidized housing, termination of a housing voucher, or an increase in rent. In some situations, VAWA gives you the right to an emergency transfer to a safer housing unit. The great thing about VAWA is that the only documentation you need is a self-certification form. You don't need a restraining order or a police report. We know it can be hard to figure out if VAWA applies to your housing situation. Talk to a lawyer so you know what protections are available to you.
Let us help you make sure you have housing choices that keep you safe. Again, we understand that many of these options come with risks. We have more information on our website, and you can call our legal helpline at 1-800-551-5554. There is support out there. Reach out to a domestic violence organization in your area or call the National Domestic Violence Hotline at 1-800-799-7233.